Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L Cohen. I am the owner of Kidon IP, a consultancy, and David L Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecution, asserting, analyzing, monetizing, and defending intellectual property rights. You can find my show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and many more services. Today, my guest is an old friend, Eric Stasik, and we will be discussing standard essential patent licensing, especially as it relates to 5G and all the interesting and fun stuff that's going on now. Eric is the owner and principal of Avvika. I think I'm pronouncing that correctly. And he's a solo professional, and he provides IP licensing and strategy services, particularly around standard essential patents. Avvika is Eric is a Philly boy who's now in Sweden, and where he lives full time. And he'll tell us. Why don't you tell us a little bit about how you ended up from Philly to Sweden, very briefly, and where the name Avvika comes from, and then we can dive into standard essential patents.
Okay, very quickly, how I ended up in Sweden. I was working for Ericsson in Ericsson's handset division in Research Triangle Park, North Carolina. And this was in 1992, 1993. And I got the opportunity to come and work in Stockholm for the chief technical officer of Ericsson, a man by the name of Jan Udenfeld. So I came to Stockholm in 1995, and I fell in love with Stockholm. And I've been here ever since. So that's how I ended up in Sweden. Avvika is a Swedish word that means to deviate, and it has kind of a negative connotation to it in Swedish, which is one of the reasons it's appealing to me. I'm a big Frank Zappa fan. Frank Zappa used to say, without deviation from the norm, progress is not possible. And I always liked that quote of his. And when I was thinking of a name for a company, that quote came into my mind. And in Swedish, you would say, utan avvikelse from normen, framsteg inte möjligt. So I thought Avvika is a perfect word. So I asked a friend of mine, one of my colleagues who I respect very much, and she said, that has kind of a negative tone in Swedish. It means to deviate in a bad way, to not comply, to leave without permission. And the more she sort of recommended I don't use it, the more I decided I should use that name. So that's the name I've been using for all these years now.
That's hilarious. Well, that's
one of my clients I'm sorry to interrupt you. One of my Swedish clients said, he looked at my card, he said, Avvika. He goes, you must be the head deviant. And I have seriously thought about changing my business card to say head deviant, but I thought maybe that's taking the joke too far.
Well, it's sort of with my name too, with Kidon. It's sort of it means the cutting edge. It means a spear tip in biblical,
spear, right.
But yeah. In modern Hebrew, it means a bayonet, and in Israel, it refers to the Mossad's assassination squad. So, a lot of Israelis get the joke, but are a little perplexed by what I'm offering.
we're not quite sure about your background, David, so we'll keep it a mystery.
If I tell you, I'll have to kill you.
Yes,
so,
exactly.
So I heard of you, I think, well before I met you in person. You were sort of legendary back in the day when I first joined in 2007. For all the good reasons and bad reasons. As you've put it, an article you wrote over the weekend made you so much fame that more so than any other piece you put a lot of effort in. But I think it's fair to say that you've been sort of one of the touchstones in standard essential patent licensing for a long time now, and you've seen a lot of changes and trends. And I've been thankful to have put together a couple pieces with you, including piece on standard essential licensing management and an update to that famous piece from 2007. And maybe briefly, if you can do it after all these years in a sentence, explain to our listeners what the heck a SEP is and why we should care. And then I'd like to get to the more interesting question of given the breadth of time that you've been in this field, what are the interesting trends that you've seen sort of generally over the past 15 years or so? And then we'll after that, we'll go into sort of some of the more interesting things that are happening now.
Oh, that's a lot to cover. Standard essential patent is a patent that is technically necessary to be used. It's necessarily infringed by a product that complies with the standard. For example, let's say 5G. If I have a standard essential patent, and I'm not going to say SEP, as many people do, I've never liked that, but if I have a standard essential patent on 5G, that means any product that complies with 5G necessarily has to infringe that patent in order to comply with the standard. Standard essential patents, because they give you this sort of market power, have always been dealt with in a very careful way by standardization organizations. They have very strict IPR policies for how standard essential patents should be accepted into standards, how they should be licensed, and they are sufficiently vague and unclear that we've been spent 30 years arguing over what the words mean.
Right. So, maybe before we jump to the next question of my laundry list, so maybe you can, because you're an engineer by training, yeah, and you practice as one, unlike many people who play in this space who can fake it maybe, but are really just lawyers or economists. Can you give maybe a few sentences on where do these standards actually come from? Like, how do they come about? And why is that maybe relevant to what we're talking about?
Well, I mean, they start at a very high level. The standards we talk about when we talk about 3G and 4G and 5G, they're actually ITU standards, which is the International Telecommunications Union. They set forth sort of these global frequency allocations, and they serve as sort of a platform for all the countries of the world to agree on a set of standards. So ITU pushes out, for example, I think UMTS 3G was called IMT 2000. It was a project by the International Telecommunications Union, which is an arm of the UN, to create this global 3G standard. They called it IMT 2000. And they took in proposals from different standardization organizations to decide which of those proposals would become the IMT 2000 standard, the global 3G standard. Typical, like a big organization like that, they approved 5 standards for 3G, only one of which really has any significance today. So it sort of starts at a very high level, and then they define frequency bands and performance characteristics. How much bandwidth do they want? How much upload and download speed do you want? What is the latency of your connection?
And is this by some diktat from up high by the black helicopter people?
No, it's an industry consensus. Basically, they say what's possible. What do we think is possible to do with today's technology, or just pushing today's technology just a little bit of an edge. So it's an industry consensus. So what I'm trying to say is at the beginning of standard starts with a very sort of broad performance goals. And then different standardization groups get together. When I say standardization groups, I mean groups of companies get together and sit down around the table and hammer out a standard. And then that's proposed to see if it meets those performance characteristics. And if it does, then maybe ITU will approve it as a global standard.
I imagine it's not a simple or clean process. It gets very messy over time.
Yeah, it's extremely complicated. When you think about the level of complexity, if you look at all these books behind me that I have, they wouldn't be enough to fill the UMTS standard, the 3G standard, and I'd have 3 times as many for the 5G standard. It's an enormously complicated thing. I mean, just in terms of the number of moving parts, and each one has to be worked out to the tiniest detail so everything works together.
So the standard is complicated. The process by which the standard is created is complicated. The process by which the standard is changed from various aspects is even more complicated.
Yeah. Right.
And when you lay on top of that the aspects of competition, because you have different competitors collaborating and patents, it becomes a really, really complicated beast.
Yes.
And so I'm sort of giving you a leading question, but so how does that impact SEP licensing, all of those complexities in your view?
This is where the FRAND concept comes from. FRAND, FRAND, which means fair, reasonable, and non-discriminatory. And it's a bit of a fudge. I wrote a chapter in a book a few years ago on this, and I took a quote from Henry Kissinger, and I said, FRAND is a constructive ambiguity, which is to say it's something that everybody can agree on because everybody has their own definition of it. We don't have to agree with the definition. We come up with a term that everybody can agree on the term, it's a bit like the one China policy. Everybody agrees on one China policy, but everybody has their own interpretation of what that policy might be. So it's a way to resolve an issue without really resolving the issue, so you can move on to something else. And I say that in the context of FRAND because the history of FRAND is really complicated because when Etsy was first being formed, it didn't have an IPR policy, and there was a lot of concern about blocking. Etsy is the European Telecommunications Standard Institute, right? They didn't have an IPR policy when they started, and there was a lot of concern in the early 1990s as Motorola began asserting its patents that hey, patents were going to be a problem in the mobile space. Who would have guessed? But there was a lot of concern in the early 1990s about this, late 1980s, early 1990s, and so Etsy, together with the European Commission, came up with an IPR policy that will allow people to contribute patented technology to a standard, and then ensure that patented technology would be available for license once the standard was released on fair, reasonable, and non-discriminatory terms. And they did this without ever defining what fair, reasonable, and non-discriminatory means. And in fact, the European Commission, in their communication from 1992, when they coined the phrase FRAND, they said it's not appropriate to be more specific about what constitutes fairness and reasonableness, since these are subjective factors determined by the circumstances surrounding the negotiation, which is really prophetic. I use that phrase all the time when I talk about FRAND, because this is a group of government bureaucrats 30 years ago that absolutely got it right.
Right.
They couldn't solve it, so I'm just going to say they kicked the can down the road and they sort of left it to the commercial world to resolve what this was. And they did it in a very hands-off way. And that's FRAND now for 30 years. FRAND
I was going to say that, sort of in my experience, again, not as long as yours in the space, but it seems that we seem to be going back to the same questions over and over again. And I was sort of curious what your sort of view of the long arc of SEP licensing history is.
It's a genius solution. It's the genius solution, because the purpose of the Etsy IPR policy is to enable Etsy, a group of competitors, to get together and produce a standard. That's the goal of the IPR policy, and to make sure that standard is available for use. Trying to make it bring economics considerations into that, trying to solve licensing problems before the standard is produced, is never going to happen. We see how difficult it is to resolve those issues once the standard has been released. So I think FRAND is the genius solution insofar as it allows Etsy to work fast and efficient. When I say fast and efficient, we've had a new generation of cellular technology every 10 years, which is staggering when you think about it. When I think about it, it's really amazing. And the reason that Etsy's been able to do it by and large because of this IPR policy that takes all these licensing issues and it pushes it outside of Etsy and it leaves it in the commercial space for commercial actors to solve. So Etsy is not a perfect solution for licensing, but it's a perfect solution for standardization. And that's what it's designed for. And the fact that the FRAND, I was going to say before I started this monologue, that FRAND first came into the lexicon in 1994 with the 1994 interim Etsy IPR policy. If you go back and you look at the clause 6.1, the licensing requirements of the Etsy IPR policy from 1994, and compare it to today, to 2021, almost no changes. There's only cosmetic changes.
Right. They
introduced specifications, which changed to technical specifications. The director of Etsy was changed to Director General of Etsy. The acronym FRAND, in quotation marks, was included after fair, reasonable, non-discriminatory, but that's it. That language has survived 30 years unchanged, and I'm going to say it's unchanged, it's substantively unchanged, which for me is an indication that this is pretty good public policy. It doesn't solve everybody's problem. It's not perfect. Licensing is still difficult, but it's the best of all possible solutions.
It's interesting, because as you well know, and we've talked about, there's a lot of cases in the courts that have sort of come around to these issues, and for years and years and years, these topics were sort of talked about in the litigations, but never actually sort of resolved. And now I have highest courts in a bunch of different countries are resolving a lot of these issues. And they seem to all be getting sort of a general consensus. And so where do you see the general consensus as to what all of this is about turning out to be?
General consensus? I don't think there is a general consensus. I think.
Well, so maybe that's the question, right? Because, the case is so, it's been around for so long. Why do you think there isn't a general consensus?
Because FRAND is designed for standardization. It's designed for the purpose of standardization. And because of that, it's an imperfect solution for licensing. And because it's an imperfect solution for licensing, it's going to be debated again and again and again. I see the same. You and I joke all the time that when you were at Nokia and you had your big litigation with Qualcomm, everything in the kitchen sink was thrown into that.
Yep.
And since then, the only new thing to come along since then that I've seen is the anti-suit injunction. That's really the only new thing that's come out.
And that's just it's a procedural litigation point, right? But as far as the substantive, I agree. As far as the substantive arguments under antitrust law or contract law or just patent law relating to SEP licensing, there's nothing really new under the sun. And it's interesting that there hasn't been different companies have changed their minds and come to agree with other companies, but sort of the issues just seem to be recycling over and over again. And it's sort of interesting, to say the least. It
is interesting, and there is some clarity coming along. I think that I just again was involved in a case where the other side was arguing that FRAND means you can't get an injunction, and I go. I said, if there's anything that's clear now, if there's anything clear in all of the legal cases that, in the surrounding around FRAND, is that injunctions are possible on SEPs under FRAND in appropriate circumstances.
Right.
But what those appropriate circumstances are, well, there's plenty of room of discussion there still. But as an outright ban on injunction, no, that's absolutely clear now, I think. So I would like to see people take that argument off the table. And at least concede it's possible under appropriate circumstances.
One of the things that sort of occurred to me, when I was at Varengo, and we talked about this a lot, is that the whole infrastructure of FRAND as it's done today seems to really be a big company game, because it's very hard for small companies to comply with it and proactively and dot all the I's and cross all the T's to sort of minimize their risk. And as someone who advises a lot of small companies in the space, I was curious what your thoughts were on that aspect of it, and if that speaks.
Yeah, it's absolutely true. This has become very much of an insider baseball game, and if you're not up on all the arcane and nuances of baseball, you're probably going to make a mistake. This is one thing I see in my work, that I see since the Huawei ZTE decision from the Court of Justice for the European Union.
It was 15, right?
Yeah, it was in 2015. I've seen sort of a improvement in the way a lot of people are behaving, or at least a lot of the interactions go. There's a little bit more structure to it, they call it the FRAND dance. Since the Huawei ZTE decision, there's more people that know the dance steps, and it's always easier to dance with somebody that knows how to dance. Doesn't mean you're gonna go home together at the end of the night, but it means that you're going to at least be able to have your interactions going to be more smooth and more more polite. And I see that now since the Huawei ZTE decision, that I think people are starting to understand this interaction. But again, these are sophisticated companies that are doing this, and a small company that just come in and saying, if they're saying what's FRAND, they're likely not going to be able to navigate these waters on their own. I think
it becomes challenging, especially for, I would imagine, the smaller companies that are trying to play into the standard space. And it does sort of speak to the bigger challenges of standardization, that the more the standardization sort of helps for the proliferation of companies and opportunities that use the standard. But the developers of the standard, it becomes much more difficult to be a small company and be part of the development of the standard, I think.
I think that's true. Yeah.
So what's new that you see now in this space? And
the
I have my
thing, The newest thing, not the biggest thing, but the newest thing is this idea, is this decision from the Supreme People's Court in China in the case of Sharp versus Oppo, where the Supreme People's Court followed the lead of the UK court and said we can determine a global FRAND rate for the Sharp portfolio. But unlike the UK court, the Chinese court laid forth a number of conditions that existed that made it appropriate for them to take jurisdiction, which I thought was almost a better thing to do than what Judge Burris didn't really motivate his reasons very much about. He said he could make a FRAND determination. All the licenses in front of him were global licenses, ergo his will be FRAND. But I don't think he understood the significance of making a global determination in one jurisdiction when he did it. And I think the Chinese court understood this when they took it on, so they were a little bit more circumspect in justifying their reasons for doing this. And if I remember correctly, it was that the company's headquarters was in China, that the main amount of their manufacturing was in China, that a significant portion of their sales was in China, that Sharp had offered a global license, that Sharp had made trips to Beijing or Shenzhen, so that the negotiations had taken place in China. There were several points that tied that dispute to China, and the fact that Sharp had made an offer for a global portfolio license was sort of the hook that they hung their justification on for them to make a global determination, global portfolio license. Not unlike what Judge Burris did, I think. So that's the newest thing, and there's a real buzz in the community now. Like, what's the fallout of that? Are people changing their licensing behavior as a result of that? What's
with Burris, at least, for better or worse, his argument was, well, we've decided which of your portfolios in the UK that you chose to assert are valid and infringed, and we can either injunct you on those patents because we determined you're not a willing licensee and you follow the rules under which an injunction would be permitted, or you can take a license, and the appropriate license would be a global license in this circumstance, and here's what it is. Yeah. And so there's a tendency to overplay what Burris actually did, not to underplay what the result is, but let's not read too much into it. I hear what you're saying about the Chinese, the Oppo case. It is limited, but it does it is one more step down the road of a court just without having determined any patents valid and infringed, and without sort of giving the option of an injunction.
Yeah, what I want to do, David, is clarify a little bit about this. That these are FRAND decisions, but they're not decisions about FRAND.
Right.
I try to emphasize this to all of my clients, everybody I work with, that the unwired plans decision is a genius decision. I think Judge Burris did an amazingly good job on it. I don't agree with everything he did, but he did it was an impressive bit of judgeship, I have to say, in that. But if you look at the facts of that case, the facts of the case supported a lot of what he did. The patents involved were Ericsson patents. Ericsson had made public declarations about proportionality. Ericsson had made public declarations about a single-digit royalty, things like this that the judge needed to decide in the case, and Ericsson had made public assertions or public statements about this. So he wasn't just pulling things out of the air. That were tied to the patents in litigation. So I think if you look at all the facts in that case, they really support what he did to a large extent. But that's kind of a unique set of facts. And he wasn't deciding on FRAND per se. He was deciding a FRAND issue with the facts in front of him.
Right.
And people take a lot of these cases, I think, and they try to read something inherent into FRAND, which isn't there, but really which came out of the facts of the case. And that's the kind of thing I try to tease out is, in different licensing scenarios, how do these facts line up? How similar we are to this type of situation, to see if that FRAND determination or if that FRAND judgment holds water in this situation.
I think that's always a danger, but it's one of the dangers of this particular profession as sub aspect of the law, which is that it attracts a lot of academics, and academics like to extract larger principles from cases, at least legal academics, whereas the law for the most part, are decisions about the facts in the case in front of them, and everything else
Right.
is as they say, obiter dicta,
Yeah.
and it's dicta, and it's not binding, and there's a challenge. But again, I understand the motivation because there's a lot of money at stake in this business, and people want to get something to hold their hat on and want some general principles.
Yeah, and also people want some general clarity. I think that it's helpful that we get clarity on some of these issues. And maybe by looking at cases like the Unwired Planet case, you get a little more clarity on what FRAND is.
So you said that the Oppo case is sort of the newest thing.
Yes. Right.
But what's the biggest thing that's happening now in SEP licensing?
The biggest thing that's happening right now, I just saw it yesterday, is ZTEs decided they are going to move in for a major monetization push with their portfolio, which is interesting.
Yes.
I look at what's happening in China with the Chinese courts, and now here's one of the big Chinese handset manufacturers with their enormous patent portfolio, frozen out of a lot of markets because of political reasons, and I think they're going to go off like a bomb. And I think that the existing players, the Samsungs and the Apples, and even Chinese competitors this is going to be a formidable problem for them.
I think you're right. I mean, because you and I know my thoughts are about the overall quality of the ZT portfolio, but that's not to say it's complete garbage. There's probably a lot of decent patents there, and I imagine that there's going to be a lot of home court advantage, especially with their close connections with the Chinese state, to utilize the Oppo decision as a leverage point for anyone who has the ill fortune, I guess, in this circumstance, to manufacture or to have a lot of not leverage, the opposite of leverage, a lot of exposure in China. And so it's going to probably change a lot of people's calculus in the telco space or even IoT space who don't necessarily want to pay the ZTE tax on top of all the other taxes out there.
Well, I don't know if it's not a ZTE tax. I don't like the idea that it's a tax. I mean, ZTE built up their portfolio mostly for defensive purposes. Well, we know
right.
If you're a ZTE,
ZTE tax was in scare quotes, Eric.
I know you're getting 30 letters a month, from patent holders. So you have an incentive to build up a defensive portfolio. What makes it interesting is that they don't need it for defensive purposes anymore,
right?
Because they're not in these markets. Like you see Huawei and suing operators in the United States. They're not in that market anymore.
Places, which
exactly,
is
they're not in that market anymore. The value that they were getting out of their U.S. patents before was cross-license, was protection from other people's patents. They no longer need that protection, so they can monetize that, turn that into cash. Perfectly okay. It's not a tax. They're just changing the way that they've been monetizing it.
So,
but it will be disruptive.
It will be very disruptive. Speaking of which, there's a lot of buzzwords that people like to throw in our space, and I'll sort of throw a few out there to you, just because I think they are connected, however tangentially, to SEP licensing, and just sort of get your reaction. But I think the two that come to the mind the most are connected cars and IoT. And so maybe tell our viewers what they have to do with SEP licensing and what you see the future is in a few sentences, to the extent you can.
I can. Okay. Well, there's this thing called IoT, which is the Internet of Things, which is everything that is electric is going to have wireless connectivity. It's going to be connected to the cloud somehow. This is the broad definition of IoT, the Internet of Things. 5G was designed specifically to support a massive number of connections, many more times connections than we have today, so to support this Internet of Things. Connected cars is a subset, a category of the Internet of Things. It's one particular thing in the Internet of Things. And it's really interesting to watch what's happened in the automotive space, because they're probably the most well-equipped to deal with SEP licensing issues. Daimler, Volkswagen. These are major corporations with they have the wherewithal, they have the means, they have the staff, they have the interest, and yet it's not been very seamless. licensing in the automotive space. You have this Avvika pool that's put together 65, 70% of all the SEPs available for license in the 3GPP space under one agreement. And I don't think they have 50% of the industry signed up yet. They've been in litigation with Daimler. Daimler was in a long litigation with Nokia. Daimler's supplier Continental got involved in it. Continental and Nokia were involved in the lawsuit. Ultimately, Daimler took a license from Nokia, but they took a bilateral license.
Right.
So it leaves them unlicensed to the other 46 or whatever members there are in the Avvika pool. And I have to say, for me, this is inexplicable. I don't get it. The Avvika license is $15, one-time, lifetime, $15 per vehicle for 60% of the patents, 65% of the patents, all the SEPs for 3GPP. It's a one-time payment, one deal. It's a no-brainer. It's the easiest thing in the world. If something like Avvika existed in the handset space, people would jump up and down for joy. They would run to them to sign up for licenses. And I think the automobile manufacturers don't know how difficult it is to go on a bilateral basis with all the SEP holders. I think they don't understand that. And so they think that Avvika isn't a good deal. They don't recognize what a good deal it is for them.
They haven't been around. You know, it's one of those things that sometimes you only learn from being burnt, you know?
I guess so. They're extremely stubborn. I think that they have their supply chain hierarchy and
we've talked about that.
Yeah, they're just but this is a tremendous solution. My friend Qasim Afzali came up with this, and I think it's a tremendous idea. I think this is the solution for IoT, and that companies should work with them and not see them as an enemy, because they say themselves they're a bridge between the patent holders and the market. That they are the liaison between those two things, and they kind of are. I don't buy that 100% because I think I mean, they're working for patent holders at the end of the day, but they are the liaison to the market, and I think the market needs to engage with them to work out deals that make sense for the market. I think that the licensing program for automotive, I don't see the problem with this. It makes a lot of sense to me. It seems really simple. You pay a one-time $15 per year for the complete suite of patents, regardless of how many connections you have in the car. Right. The simplest thing in the world. $15, I pay it once, I'm done.
And if you were to, I think we've calculated
it's the cost of a car wash.
It's the cost of a car wash. But if you add up a la carte all the other ones, all the other licenses bilaterally, it comes up far in excess of 15.
Yes, exactly. Plus the transactional cost of having to deal with it, and the uncertainty, and just the hassle of having to negotiate all these separate licenses and then follow them and maintain them and comply with. I don't understand it.
So you've been in SEP licensing for a long time, and if you talk to some of the real advocates for standardization, I should say, you know, they want everything to be standardized. They want the standardized process to apply to all different things and all across all different, whether it's pharmaceuticals or whatever.
Yeah.
What do you think are sort of some of the takeaways on sort of this macro scale that you know, if anyone is thinking that, you know, any policy folks are thinking, oh, we should start standardizing these areas of technology. Look how successful telecom. I think there was actually when there was an op-ed piece I read who was pointing, the author, I forget his name, was directly pointing to the success of telecom as how we should do vaccines and the whole standardization process. Given the fact that, for example, pharmaceuticals is just as patent rich as in its own way as you know, high tech and telco. What do you think are some of the takeaways that you've learned over the years from this space?
David, I was going to interrupt you because halfway through that question, this is way over my head. I thought I don't have the faintest clue. I work so much in the trenches. I don't really have any 10,000 foot view of things. I would say though, and I've said it before, that if you want to look at a example of economic success, look at the cellular industry. I mean, you can't. It boggles my mind. I started in 1992. I was one of the early people. And I guess we had the first GSM call was 1991 or 1992. So I've been in for a long time, and I've never seen an industry grow like this. in terms of the products that we're able to bring to the market and the things we're able to do now. What would take it took 1,000 hours to download a movie over 3G, over GPRS, which was the first sort of data connection. 1,000 hours. It takes 3 minutes now over 5G. I mean, just this, and I look and I sit on I kind of feel half guilty because I look and I sit on the subway and I see everybody with their phone in their face. And I think, oh my God, what have we done? I mean, I can understand the social impact of that, but the technology as a business, in terms of its product development, I can't think of anything that's been more successful than the cellular industry.
If I could be your marketing guy, I've heard you on a couple of panels in different contexts say things along the lines of that I'm no academic, I'm no lawyer, I'm no judge, I'm just a practical guy who's a businessman trying to do licensing.
Yeah.
And I think what the takeaway is that, you alluded to that before about Frand being sort of a nice little excuse to kick the can down the road so people can get with the technological development, and that Frand is really what is sort of a function of what the business folks can come up with, and as long as it's not obviously violative of competition law or other obligations. I think that's the takeaway, which is they need to have the experience of someone like an Eric Stasik who's in the trenches to sort of keep shaking them and say, enough with this academic crazy ideas. Let's try to be practical.
Well, this is the thing that I run into a lot. I mean, I deal with a lot of economists, and most of them are very, very fine people, but they're academics and they look at it like economists. And I've read reports that economists write about licensing and SEP valuation, and they use terms and language and mathematics that I have never in my life even seen. And I think to myself, that's not how it works. That's not what we do. And I've said this before. My job is really unsophisticated. It's not. It's. I'm a fishmonger, basically. I know fish. I know what fish cost. I go and I look at your catch. I pick up a couple of fish. I smell them and they look good, and I can give you a price. And then we haggle back and forth, and I go home with some fish. It's really not more complicated than that. And everybody thinks I'm sort of using an extreme example, but it's really not. Once you get past the standard essential patents and the claims and the technology and arguing over claim charts and things like this, it's a negotiation over price. And some of the most effective people I've seen negotiate SEP licenses haven't been lawyers or licensing experts. It's been people in commercial purchasing. They're good at buying batteries. They're good at buying screens. They know how to negotiate.
Right.
They see how to make a commercial deal, and that's what this is at the end of it. This is a commercial process.
And I think it's I guess what I'm trying to say is that appreciation for that fact gets lost often in these titanic debates that fill up volumes and volumes of scholarly journals about what was.
I had the great fortune. Sorry to interrupt you, David. I had the great fortune of being in a mediation in, I want to say 1995, right around when time when I moved to Sweden. I was in a mediation in California with a retired federal judge, and I had been having a back and forth with the owner of this patent, who was suing Ericsson for $1 billion. And so we were talking, and the patent was a completely bogus claim. It was a completely bogus claim. He was twisting the words of his patent, and he was a smart enough guy. He knew what he was doing. And so we're having this argument over the patent, and the judge slams his fist on the table and he yells at me. He goes, Mr. Stasik, patents are about money. Quit talking about patents and start talking about money. and that stayed with me. It really made an impression on me. At the time, of course, I was kind of shaken off. I was shaken by it. He yelled at me like that. And, but he's right. At the end of the day, this is about money. And people that want to find a deal, that want to work together, find a way to work together.
Right. Right.
Despite the complexities of it. And if you don't want to work together, there's enough complexity in Frand to make it so you never make a deal if you want to do that.
Yep. Yeah, no, and I think one of your specialties is you're good at smelling out when people are trying to play that game.
No, but it's not. I don't think it's so much of a specialty. I don't think it's any particular skill. Everybody's
Well, not how to do it, but but there's a lot of.
Okay, but everybody's bought a car, right? Not everybody, but most people bought a car. And it's one of the few things in life that some people they haggle over. Most people, they just buy the price and they take it. The haggling is something that you do in India or you do in Asia or something. But most people don't haggle except for when they buy a car. And everybody knows how it works. The dealer makes you an offer, and you know that the offer's high. You know that. You know that there's some room, right? How much room? That's what you want to find out. And my example is I see, let's say a Volkswagen Golf. It's a $30,000 car. If that's the sticker price on the car, and you walk into the dealer and you take a test drive and you kick the tires and you look at it and say, oh, I really like this car. I'll give you $100 for it. This is what I see in a lot of commercial FRAND negotiations. That the implementer will say, oh, I'll give you $100 for it. And you're looking for $30,000. I can't give it to you for $100. And they go, well, your $30,000 is an unrealistic price. It's just too high. Make another offer. Bring it down. And the two sides start out so far apart from each other, they're never going to make a deal. If you try to buy a car like that, if you don't get thrown out of the dealership, you'll certainly end up walking home. You can't. Everybody knows that if I want to get a good deal on a car, he says it's $30,000. I'm going to say, okay, I don't want air conditioning. I'm going to take some of these things off to try to bring the base price down. Fair enough, I do this. Then until I get down to the bare bones, then I'm going to make him an offer somewhere under that, but high enough so that the dealer's going to say, okay, this is a serious buyer. They made a serious offer. It's a lot less than I want to take, but it's enough so that I can deal with. I can negotiate with this person. All of the successful FRAND negotiations I've been in follow that trajectory. All of the unsuccessful ones I've been in follow the other trajectory. I'll give you $100 for this car, and then they say, okay, you back and forth. You show them some more claim charts. You say this car's got all these extra great features. Okay, 150.
Right.
That's you can't work with that. And all the unsuccessful ones go like that. So that's sort of my takeaway. If anybody out there is trying to get any wisdom for anything I say, if you see yourself in that situation, you're probably headed for litigation.
Right. So Eric, for our viewers out there, maybe give a little more precise. What do you offer your clients? A little more precision.
What do I offer my clients? I call myself an SEP licensing expert because I think that's really about the only thing I'm an expert in. I'm an expert. I have to say, just because I've been around for so long. It'll be 30 years in May when I've been working with SEP licensing, and this is all I've done for the last 30 years. I've worked for Ericsson for 10 years, so I know big company, I know corporate structure. I worked as a consultant now for almost 20 years, and I work for all kinds of companies. It's one of the funnest things about being consultants. I have big companies, I have small companies, I have non-practicing entities, I've got individual inventors. It's a mix of everything, and I really enjoy doing that. And
so I know you have testified for experts as a licensing expert. You've helped actual negotiations. You've come up with licensing strategies.
What I like to do is I'm a negotiator. I like to sit down and discuss claim charts and discuss royalty rates and sort of work out deals. That's what I like to do the most. I do that for some of my clients. They entrust me with that, so I'm the one that negotiates the licenses for them. I've done that for a number of companies. I also work sort of with licensing departments as an extra man, sort of help out in big projects, things like that. I'm happy to do that. I do expert witness work. I have to say it's the least enjoyable thing that I do. And I would be very happy if I didn't have to.
You don't like to be cross-examined, Eric?
I don't mind being cross-examined, but I don't like being manipulated, I have to say.
Right.
And I'm never say anything bad about any of my clients, but it's a natural thing. Attorneys are advocates for their client, and they try to zealously represent their client. And oftentimes that means trying to drag their witnesses along with them. And I detest that. I'm one of the reasons I'm independent is because I'm independent, and I don't like people telling me what to do. So that
as a former litigator and as someone who's managed large litigations for years, I find witnesses like yourself who are a little stubborn and very opinionated, but also knowledgeable, tend to be challenging, but the best witnesses. Because once you agree on a position with the law firm and the witness, you become like a rock.
Yeah, well,
I know you don't take compliments well, Eric.
I'm conciliatory by nature. I really am. I'm easily persuaded by other people's arguments. I like to think that I have an open mind, although it may not appear like that sometimes. So yeah, I can be convinced to change my position on things, but I don't like it when people try to put words in my mouth.
Right.
And that's
right.
that's probably the most difficult thing I do in this expert witness work. And I understand that me being completely candid is maybe not the best thing for their client, but that's the way it is.
Well, so where are most of your clients? Are they global?
Mostly in Europe.
Mostly in Europe.
And I find it just convenient for time zone purposes. I have one case now that I'm working with a West Coast U.S. law firm, and the 9 hours is a bit of a complication.
Yeah, I feel your pain. Yeah, no, that's challenging. But most of your clients. And how should if someone wants to get in touch with you, how should they get in touch with you?
You just Google my name at the bottom here. There it is.
Yeah.
Right there. Just Google my name and you'll find me. It's that simple.
And email, LinkedIn?
Email, it's on my webpage. If you go to www.avvika.com, you'll find me there. I never update my webpage. If I didn't have to have one, I wouldn't have one. But you can find me there. And I think easily or you go into LinkedIn and type in my name as well.
You're pretty prolific on LinkedIn, if I do say so myself.
David Cohen, on the other hand, is very hard to find on Google. You'll find there's quite a lot of David Cohen.
Yeah,
LinkedIn, David.
They're rather common.
Doesn't help much. I think there's 2 or 3 David L Cohens as well.
Yes, no, I think the next my biggest competitor is now ambassador to Canada, so it's tough. But so Eric, thank you. Well, any parting thoughts about SEP licensing you want to share with the folks out there?
No, just yeah, beware.
Beware. All right. Well, thank you very, very much, Eric. It's been a pleasure as always, and looking forward to chatting with you many times again. But thank you all to our viewers for tuning in and listening to Eric Stasik, SEP Licensing Management Extraordinaire.
Thank you, David. I hope the next time we talk, each of us has a beer in front of us.
Yes, indeed. Yes, indeed.
Cheers. Okay.